Hi. In the last episode, we talked about coexistence and consent agreements in real world trademark disputes. So, when you get a cease and desist letter, when there's negotiations between companies, and the agreements that are meant to keep the peace and let the two brands coexist. Today, we're taking the same concept, but we're putting it inside the process with the USPTO when a trademark is being examined. And coexistence and consent agreements show up all the time in trademark applications. When you get a refusal by the USPTO, it's technically called a Section 2D refusal, which is based on the potential or likelihood of confusion between two marks. Coexistence and consent agreements come up in that context, but they also come up in the context of when oppositions are filed or even cancellation proceedings within the Trademark Trial and Appeal Board setting. So any type of issue within the USPTO relating to the potential of confusion between two marks is where consent or coexistence agreements might come up. And this is what surprises a lot of founders. Even if both parties agree, so say you've gone through the process of negotiating a consent agreement or a coexistence agreement, but even if the parties both agree to those terms, and even if everyone signs the agreements, they're fully executed, the USPTO does not have to accept the agreement. So just because the two parties say, we don't think there's a likelihood of confusion or our agreement is going to resolve the risk of confusion, the USPTO or the Trademark Trial and Appeal Board may disagree. They may not feel that it's going to resolve it. They may feel like it's not a resolvable problem. And so they may not accept the agreement as a way to enable one brand to go ahead and move towards registration or to resolve the risk of confusion between two marks. Today, we're going to talk about when consent agreements actually work at the USPTO and when they don't, and why agreeing too quickly to one can cost you leverage that you may need later. If you've ever been through the trademark registration process before, then you know kind of what to expect. But if you have never been through it, let me start by setting the stage for you. When you file a trademark application in the United States, you don't automatically get registration. Your application has to be reviewed or examined by a trademark examiner who's an attorney who works for the United States Patent and Trademark Office, the USPTO. And that examining attorney's job, or we also call them an examiner, is to protect the public from confusion in the marketplace. I call it a consumer protection mechanism. You'd think that trademark is there to protect business owners, but it's really there to protect consumers and making sure that they know who the source of their goods and services are. So the examiner is going to look at your application and ask questions like, is this mark too similar to another mark that's already registered or one that is already pending previously in front of the USPTO? Are the goods or services the same, or are they similar or related? How similar are the marks? Could consumers reasonably believe that these two brands are connected or maybe even are the same brand? And if the examiner sees a problem, they issue what's called an office action. It's also a refusal. An office action is basically the USPTO saying, we're not approving this yet, and here's why. And one of the most common reasons for this type of refusal is the likelihood of confusion refusal, which is also called a Section 2D refusal. Section 2D just refers to the section in the trademark statute, the Lanham Act, that governs trademark registration in the United States. All this means is that the examiner believes your mark is too similar to an existing trademark and that having both marks on the register could confuse consumers. Founders will read the refusal and think, but we're not the same company, or we don't sell exactly the same thing, or our branding looks different, or my word is spelled differently than the other brand. There's lots of reasons why founders think there isn't a risk of confusion. And this is where the idea of coexistence comes in, or a consent agreement, is founders often assume that if the other trademark owner, maybe the one that owns the registration in the mark, is okay with it, with coexisting, then the USPTO should be as well. The immediate thought becomes, well, let's just get consent from the owner of the registered mark. And that's where a consent agreement would enter the picture. And as I mentioned in my last video, a consent agreement is an agreement where the owner of a cited trademark registration says that they will consent to the registration of a newly applied for trademark registration, usually with some explanation and conditions meant to show why the confusion won't occur, or limitations on the newly applied for mark's use so that it prevents the risk of confusion in the future. But consent agreements don't just show up during the application review stage. They also come up when there are trademark disputes that have been formalized. So after your trademark application is approved and published by the USPTO, which is the last step before registration, that publication period gives third parties the ability to oppose your registration. So if another brand believes that your mark, if it is registered, would conflict with theirs and potentially cause damage to their trademark rights, then they can file what's called an opposition. And an opposition is handled by a specialized tribunal inside the USPTO called the Trademark Trial and Appeal Board, or TTAB for short. And similarly, if you already have a trademark registration, another party who believes they have superior rights to yours can file what's called a petition to cancel with the TTAB. Even when you get registration, you're not necessarily in the clear if there's a potential of confusion with an existing registered mark that has prior or senior rights over yours. These are technically administrative trademark proceedings. They're not court cases, but they are still legal disputes, and they really do function as litigation. They involve pleadings, they involve deadlines, evidence, legal arguments, and the cost can really add up quickly. So once an opposition or a cancellation is filed with TTAB, many mark owners start looking for ways to resolve the dispute without fully litigating it. And very often, one side will propose coexistence or a consent agreement as the solution. And on the surface, it can feel efficient. Why fight when you can agree, when you can settle and come up with some type of compromise? But this is where founders need to be especially careful, because not every consent or coexistence agreement actually solves the problem, and not every agreement will be accepted by the USPTO or the TTAB. Now, sometimes consent is a smart settlement tool, but there are two big things founders and mark owners need to understand. First, you might not want to agree to consent, even if it resolves the immediate dispute. And I did talk about that in my last video in quite a bit of detail. Second, even if both parties agree, the USPTO examiner, or the TTAB, they're not required to accept your agreement. They don't have to agree with you that it solves the problem. So let's start with the first question, and I will go over this again. Should we agree at all? Why might you not want to agree to a consent or coexistence agreement in a USPTO-centered dispute? Well, the first reason is it can permanently change the trademark landscape that you're operating in. If you consent to the registration of this other mark today, you may be giving up the leverage that you need tomorrow. And you're on the record with the USPTO saying you agree to their use, and that can be used against you. If they later expand into adjacent goods or services, your prior consent can be used against you to say that you didn't think there was a likelihood of confusion. And if the agreement is drafted too broadly, it may restrict your ability to expand while allowing them to expand. And remember, trademark registrations can last for decades. And so a consent agreement signed to solve a problem this month or this year can quietly shape your business for the next 10 years. There's also a strategic reality that founders often miss. Sometimes the best resolution is not consent at all. It's forcing the other party to narrow their goods, amend their application, accept limitations, or even abandon a weak filing. Consent should never be the default fix, especially when you have the superior or senior rights. Let's talk about the second question. Does consent always work with the USPTO? And as I've mentioned, the answer is no. Even when both parties agree, the examiner still has an independent duty to prevent likely consumer confusion. That is their main goal. And so they're going to look to see whether the consent agreement actually addresses confusion in a meaningful way. A bare consent, and that's actually a term of art in the trademark space, is basically a sentence that says we consent, and just a bare consent to coexisting or allowing this other mark to exist is often not enough. The USPTO wants to see very real practical safeguards. They want to see clear boundaries. They want to see articulated limitations. They want to see differences in channels of trade, differences in how the marks are being used, and a clear explanation in writing as to why confusion is unlikely between the two brands. Even then, acceptance is not guaranteed. And that's why you'll sometimes see situations where both parties agree and the USPTO still maintains the refusal. So here's a quick decision framework within the USPTO context. So ask first, are both marks genuinely able to coexist without confusing consumers? That's obviously the most important question. If you don't think that's possible, you shouldn't be agreeing to a consent or coexistence agreement. Next, ask, is consent strategically wise for your business long term, not just for this application? Like, what kind of limits is it going to put on your business in the long term? And does the agreement include meaningful safeguards, or is it just trying to bypass the refusal? It's like a persuasive tool. When you're in front of the USPTO, the terms of the agreement have to be persuasive to convince the examiner that likelihood of confusion doesn't exist between the two brands. Then I would also ask, are you accidentally weakening your own brand by reducing exclusivity of use of that mark? If you are, your brand is not as strong and you're diluting your rights. And especially if you're the senior rights owner, I would never agree to weakening my rights under any circumstances. Now, if you're the junior owner and you're trying to get registration, obviously you're trying to get the senior owner to reduce their exclusivity. That's the whole point. But I find that it's not always in the senior mark owner's best interest. And then ask what happens if either party expands later. What if there's a dispute? What if the terms are too limiting? What if one of them breaches the terms of the agreement? You're going to have to enforce those terms, and that can be expensive. So here are red flags specific to the USPTO context. If consent is being used to avoid narrowing the goods, that's a big red flag. Sometimes the USPTO will allow coexistence when the parties agree to narrow the field of goods and services they're offering so that it opens up space between them and there's less risk of overlap. If the consent is being used to not have to narrow that scope, that could be a red flag. Look to see if the agreement is vague or lacks real operational boundaries. So if it doesn't really give any guidance on that, and any dispute would have to be litigated to be resolved, that's problematic, and the USPTO will not like those types of terms. If it benefits one party's registration far more than it protects your brand, then that should be a big concern for you as well. Look to see what you're giving up, and do you really want to do that? And what are you getting in exchange for making that concession? I would look to see if it's being rushed just to get an application through. Maybe there's a filing deadline, like a response to an office action in there. Slow it down, particularly if you have leverage in the conversation. And then if it's limiting your growth while letting the other party keep flexibility, that is also problematic. Also, if it's limiting your ability to get registration, sometimes that happens in these agreements. And so you just want to look and see what you're giving up compared with the leverage that you genuinely have in that situation. And again, I would never go this alone. This is where having a good trademark lawyer really matters, because in a USPTO dispute, the goal isn't just to win the procedural fight. The goal is to protect your long-term ability to use, expand, enforce, and invest in your brand without creating future conflicts that you didn't intend or limitations that you didn't intend. So if you're dealing with a 2D refusal or likelihood of confusion refusal, or an opposition or a cancellation proceeding, and someone is proposing consent or coexistence, this is the moment to slow down and get strategic. If you want help evaluating whether coexistence or consent makes sense, if you want help structuring an agreement that the USPTO is more likely to accept without compromising your own brand's future, that is the work that I do with founders and growing brands every day. So just schedule a call with me. We can talk through your particular situation, and I can help propose what I think is the best solution for you that will preserve your ability to exist and grow as a brand as you intend. Because resolving a trademark dispute is not the same as resolving it well and in a way that protects you. As we wrap up this episode, here's the thread that connects everything we've talked about. Coexistence and consent agreements don't usually fail because founders are careless. They fail because founders and brand owners are trying to be practical, efficient, and optimistic. And optimism is not a legal strategy, unfortunately. These agreements can work when they're carefully, narrowly tailored, carefully structured, and aligned with how a business will actually grow. But when they're rushed, when they're one-sided, when they're treated like checkbox or paperwork instead of strategy, and really using the leverage you have in the conversation, they can quietly limit your brand long after the original dispute is forgotten. So if there's one thing I want you to remember, it's this: avoiding conflict today should never come at the cost of your future options for your business. If you're facing a coexistence or a consent decision, whether it's tied to a cease and desist, a trademark application, or a USPTO dispute, it's not a moment to rush and just get it done. That's a moment to take a step back, understand your leverage, and make sure that you're not solving one problem while creating an even bigger one that you'll have to deal with later. So if you want help thinking through that decision, that's exactly the kind of guidance I provide, because the most expensive trademark mistakes are not always lawsuits. Sometimes they're the agreements that you signed to avoid one.